Ben Franklin's World is a production of the Omohundro Institute.
Welcome to Ben Franklin's World, a podcast about early American history with Liz Covart. The study of history is key to understanding who we are and how we can affect a better future. Ben Franklin's World will introduce you to historical people and events that have impacted and shaped our present-day world. And now, here's your host, Liz Covart.
Hello, and welcome to episode 227 of Ben Franklin's World, the podcast dedicated to helping you learn more about how the people and events of our early American past have shaped the present-day world we live in. In this 21st century, we have all become creators and users of content. We take original photos with our smartphones, generate blog posts, podcasts, and digital videos. Some of us write books and articles or paint works of art. Some of us compose and play music. And nearly all of us contribute some form of tweet or update to social media. We also enjoy borrowing materials from our local libraries and viewing movies or listening to music from our favorite subscription services. Needless to say, we consume and generate a lot of information and content, which makes it really important for us to understand copyright and fair use. Now, copyright is the bundle of legal rights that allows us to decide how we want to share and distribute our original creations, while fair use allows us to access and use existing copyrighted works so that we can create new works and further add to and build our national culture. Both of these principles have an early American past. They're ideas that the earliest English colonists and the founders of the United States grappled with. And as this week, the last week of February, marks Fair Use Week, an annual celebration of the important doctrine of fair use, it seems only fitting that we dive into this fascinating history so that we can better understand these legal principles and how they impact the works we create and use today. Kyle Courtney is a lawyer, librarian, and copyright advisor for Harvard University, and he will serve as our guide through the early American origins of copyright and fair use. Now, during our investigation, Kyle reveals details about the legal concepts and principles of copyright and fair use, precedents and influences of British American and early United States copyright laws, and why copyright was seen as so important to the development of the United States that the delegates to the Constitutional Convention wrote a copyright provision into the Constitution. But first, copyright and fair use are rights worth celebrating. So the Omohundro Institute's digital projects team created bonus materials so that you can further explore the history of these topics. Within the OI's free OI Reader app, you will find comics created by Kyle Courtney and his Fair Use Week team that detail the history and origins of fair use in the United States. You'll also find a bibliography or list of books about the history of copyright and fair use, and a special blog post by Nora Slonimsky that investigates the public figure exceptions to early American copyright laws. Plus, we have bonus audio, a listener Q&A featuring Kyle answering your questions about copyright and fair use. This bonus audio track is only available in the OI Reader app. So open the OI Reader app on your favorite smartphone or tablet device, or head on over to your favorite app store and download the OI Reader app for free. All right, are you ready to embark on a journey through early America's legal history? Let's go meet our expert guide.
With tidings and wisdom to share about our early American past, here is this week's special guest.
Joining us is a lawyer, librarian, and copyright advisor for Harvard University and a professor of cyber law at Northeastern University. He works closely with Harvard Library to promote a better understanding of copyright issues. And in 2014, he founded Fair Use Week, an international celebration of fair use sponsored by over 100 libraries, universities, and other institutions. Welcome to Ben Franklin's World, Kyle Courtney.
Thank you very much.
So Kyle, you're a lawyer with a specialty in copyright and fair use, which means you must think these particular aspects of the law are really interesting and important. In fact, you founded a week to celebrate these legal ideas. So would you tell us about these aspects of law and what you find so interesting about them?
Sure. I am completely biased, and I think copyright is the most exciting topic possible. And I think it's a topic that connects with everyone because we're all ultimately both creators and users. And that squarely fits in the peg that is copyright law. So when I was emerging from law school, and I also went to library school as well, I saw this as an exciting opportunity for museums, libraries, and cultural institutions to really kind of understand this right the best out of all the different facets of society we have, because often we're the ones that are collecting, preserving, purchasing, using, and allowing access to all our communities to these copyrighted works, whether they be films, books, music, architectural drawings, and everyone seems to like this in that they all have an opinion on copyright and fair use. So it's been a fascinating area to study and explore over the years.
Now, when we say copyright and fair use, what are the actual legal concepts that we're referring to?
Sure, absolutely. So you can't just copyright anything. Copyright is essentially a bundle of rights for particular subject matter. And as I said, these could be literary works, these could be audiovisual recordings, these could be articles, film, anything you can imagine. But certainly it doesn't protect everything. So ideas, systems, concepts, principles, facts, those are not necessarily copyrightable. The expression of those ideas or facts may be copyrightable, and sometimes that's where we leak into patent law a little bit. But the idea is that I created something that is unique, it is new, it is creative, and it is fixed in a tangible medium of expression. That's the legalese. But basically it's there. And I want to be able to share it with other people. And so I have a bundle of rights, which allows me to decide for a limited time period of where I want to distribute that work, if I want to make copies of that work, if I want to put it on the internet, if I want to publish it, if I want to print it. So it's a authors-based, or in really good parlance, a creators-based right.
So copyright really just allows a creator to be able to put their ideas out into the world and then have some sort of control over how those ideas are disseminated.
Certainly, yes. So it comes with, the beneficial bargain is you get to control for a certain time period your copyrighted work. And then you can, distribute it as will. And other people can use it, but they have to seek your permission during that time period. But the end result also is the benefit of the bargain goes to the public, because after your limited economic monopoly over your copyright expires, the public gets it. It drops into the public domain. And therefore, anyone could use it, take it up, put it on a t-shirt, make a play out of it, whatever they want to do without seeking your permission. So I always think that copyright is really a trifecta. It's the bundle of rights for your creation that you have a limited economic monopoly for a certain period of time that eventually will benefit the public at large.
What I find fascinating about copyright is that we can find a provision for it in the Constitution of the United States. In Article 1, Section 8, the Constitution grants Congress the power to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, end quote. Kyle, copyright was important enough to the founders that they wrote it into the Constitution. And I wonder, do you know why they thought it was so important? Why they wanted to protect the writings and discoveries of authors and inventors?
Yeah, it's very exciting. It's mentioned in the Constitution. I think the next thing that's mentioned is like the creation of the post office or something. So it's a very big part of this. We know there was not a lot of debate at the Constitutional Convention about adding this copyright clause. But as we know, the convention members were well aware of creation and putting ideas and control over those ideas. Half of them were writers and inventors themselves. But they were also very keenly aware of the idea of control and censorship as we emerged from being a colony under English rule. And in the early days of the colonies, and I'm going back 100 years before the convention, there was a fantastic quote by Sir William Berkeley. He was Charles I's royal governor of Virginia. And he said in 1671, I thank God there are no free schools nor printing, and I hope we shall not have these for 100 years. For learning has brought disobedience and heresy and sex into the world, and printing has divulged them, and libels against the best government. God keep us from both. Now, that's an amazing quote, because he was accurate in that 100 years later, the Constitutional Convention would be debating this very subject. But certainly, they had a lot of creators come to them and lobby for some level of federal protection. In 1783, the Continental Congress received a copy of Connecticut's first attempt at a Copyright Act, which was one of several state laws on copyright. And they said, this looks good. Let's form a committee to consider I believe the quote is, the means of cherishing genius and the useful arts through the United States by securing to authors and publishers of new books their properties. And James Madison, Virginia, Hugh Williamson in North Carolina, and Ralph Izard of South Carolina were put on this committee. And we don't know any of their debates, but what emerged from their report was nothing is more properly a man's own than the fruit of his study, and that the protection and security of literary property would greatly tend to encourage genius. So they came out with a great copyright federal approach almost immediately. So we can see that certainly these themes have played out throughout the development of copyright law and was right there in the beginning of the constitutional narrative as well.
Given that so many of the delegates to the Constitutional Convention were themselves writers and inventors, do you think that's why they embedded the power to establish copyright into the Constitution? Or do you think it's because they believe that copyright protections provided some sort of greater purpose to the new nation?
I think by putting in the Constitution, you let the world know, or as I would say as a lawyer, put on notice that the federal government considers this a very real and valuable asset to the authors and publishers themselves. At the time beforehand, under the Articles of Incorporation, each state may or may have not passed a copyright law, and very famous folks like Noah Webster were having a heck of a time running around preventing piracy. They would have to go from state to state to state. So I think certainly we see that by putting it in the constitutional narrative, they were putting it in line with many of the other rights that they wanted to federalize and saying this helps us centralize government in such a way, but it's granting authors these rights, which is kind of interesting. It's not saying it goes to the printing presses as it had in England prior to that. It's not saying it goes to the publishers, it's the creators. And certainly the fruits of their labor, they should have a certain advantage to allowing protection to exist amongst the 13 colonies during that time and later the federal government. So I think they understood it. The grappling, however, I would imagine at the time period was the fact that they turned it into a monopoly, something which they may or may not have been comfortable with at that time period.
So what's the evolution of American copyright law? We know that many American laws have a deeper and longer tradition in history that extends well before the creation of the United States. So what are these longer and deeper historical traditions for copyright law? Where did Americans come up with the idea that they should offer authors and inventors protection for their work?
Oh, well, like many good American ideas at the time period, it was borrowed. I, of course, was an Irish history major in a past life. And so I love that one of the first copyright concepts was enshrined in some ancient records of Irish King Dermot. And he actually heard a copyright dispute in the 560s BCE between Abbot Finian, who was in charge of a church over there, and St. Columbia. And now he wasn't a saint yet because he had copied some of the abbot's Book of Psalms, I think word for word. And the king settled the dispute in favor of the abbot, and he stated in Gaelic, "To every cow her calf, and to every book its copy." And here we see the first real interpretation of authors' rights. That concept that this is the fruits of almost a natural copyright. You created this, therefore you should have rights in this. But arguably, ever since that case, I think the next great European influence, at least on American law, would be the Movable-Type printing press. Venice, Italy, introduced a new concept of granting printing licenses for people to have access to these printers. And the Venetian Senate was very active in the 15th century, granting certain printing rights or monopolies, which we would later observe as the origins of copyright. One of the famous German printers, Johannes de Spira, he got a 5-year monopoly to publish Cicero's letters in 1469. Years later, that same Venetian Senate acted again and gave the sole right to publish the history of Venice to the historian of Venice for 5 years. And they also added a fine for infringement. So if unauthorized printing of the book occurred, they actually had a fine given out there. And that wasn't really the first. Germany saw around the same time that you could infringe and they would punish you for that infringement, but also heirs could be granted copyright of their deceased relations. Albrecht Dürer's widow claimed an exclusive right to publish his works. Now, he was a painter and printmaker during the German Renaissance. His woodblocks are very, very famous. And he was a correspondent with great masters of the time period, Raphael and Da Vinci. So he had a copyright notice against piracy in one of the earliest parts of his book. And what's really interesting about this is it's a mandate from the government, and he's warning you not to infringe. And I have to just repeat it for you here because it's amazing. In the opening lines of his books, it says, "Hold, you crafty ones, strangers to work and pilferers of other men's brains. Think not rashly to lay your thievish hands upon my works. Beware, know you not that I have a grant from the most glorious Emperor Maximilian, that not one throughout the imperial domain shall be allowed to print or sell fictitious limitations of these engravings? Listen and bear in mind that if you do so, through spite or through covetousness, not only will your goods be confiscated, but your bodies also placed in mortal danger." That is one of the best infringement notices I have ever read.
Yeah, that is quite the warning. Now, it does sound like copyright was a European invention, where the Italians maybe modified that Irish king's edict and the Germans modified that Italian law. And I wonder where the English fit into this picture, as many American legal precedents come out of the English legal tradition. So how did the English innovate on this process of codifying copyright?
The English were paying attention to what was going on in the continent for sure. And I would argue, and I think a lot of scholars would make a similar argument, that copyright in England was the foundation for many types of what we refer to as modern copyright laws. Now, the English grappled with the same problems that their peers had grappled with in Italy and Germany, but English copyright law has a great influence on U.S. law, much like most of the ideas we had. And this goes back to Henry VII, actually. He appointed a first royal printer and said, "You get to print all the official documents of the government." It was such a popular position that they added a second royal printer for religious sermons during that time period. And Henry VII was keen on copyright and granted copyright privileges. And they even saw some copyright piracy cases in the beginning. It continued right on with Henry VIII. And he created something very interesting. And I think this has the greatest of influence on American copyright law. Not that we imitated it, but we learned our lessons from it. Henry VIII continued the tradition that his predecessor had done, but now all new books had to be approved by the Privy Council before publication. And that remained in effect until about 1694. And this is where the origins of copyright and fair use reveal their emergence from two distinct paths. One, first and plainly, I believe, is copyright emerges to protect the right to make copies. At the same time, this was more akin to a right to vend, but eventually this became copyright. But secondly, copyright at this age emerges as a means of censorship and control. So you have the king, you have the Privy Council, you have the Star Chamber, and those positions could prevent books, pamphlets, and anything else that was being printed from being printed at all. You can grant or deny charters to allow people to access the book trade. And this printing press was controlled by a royal grant to an organization called the Worshipful Company of Stationers of London. Now, we simply just call it Stationers Company nowadays. But they ran all the printing presses in London under a monopoly from the government. So if a book was critical of the government, or those in power wanted to prevent the spread of, say, the Protestant Reformation, they could simply refuse to print the book. And there were no real other options at that time period, at least as far as fast printing. So again, copyright emerges from both copying and censorship, which is the path, I believe, of why fair use becomes such a critical part of the First Amendment narrative and free speech analysis we have under U.S. law. But let's say you did publish with the Stationers Company, which is fantastic, right? Your book was accepted, Privy Council approved. The author didn't see real profits from the sale of these copies. Often you were paid once by the printer, and then the stationers would collect the profits from the copies that were sold. So authors did not have any real economic incentive to continue to, create plays, works, textbooks, drawings, if they saw no real profit other than maybe a one-time payment. I've argued that, this would really create an intellectual brain drain in Europe if it continued.
Yeah, it really sounds like these early English laws were meant to control, as you said, the flow of news and information to the people. So when and why did this desire for control or practice of control change?
Yeah, so the monopoly by the stationers, I think, irked a lot of people, right? Especially, I think, people that were creative in writing books. And this is the formation of, the earliest kind of novelizations and what we would refer to as magazines, I guess now, or pamphlets. And so turns out that after 100 years of this monopoly, this was inconsistent with the spirit of the Age of Enlightenment. So this unchecked monopoly became unattractive. And so we needed to create, or at least the writers of the time period said, we need to incentivize new works. And we don't have to worry so much about censorship. We're supposed to be enlightened here. So the Statute of Anne was proposed in 1708 and passed in 1709 and 10 also, when it was published. And it was a new authors-focused right. So instead of the top-down saying, you now have a right to print, this was saying the creator has rights. Now, during this time period, the Stationers' Company petitioned for perpetual rights, but Parliament rejected that and said the exclusive right to publication shall be set to a specific term of years, and it will limit the power of the stationers. And so the authors, for the first time, were granted an exclusive right to reproduce their works during that duration, and that duration was 14 years. The authors could then renew for an additional 14 years, and then after that, it would drop into the public domain. So here we see the first creator-focused statute, and the stationers were out of luck on their monopoly. Now, the advent of more technology and faster and greater printing presses certainly helped, but I don't want you or your listeners to think that the Stationers' Company was out of it completely. In fact, they remained involved in the administration of rights. So you still registered your work with the stationers. You still renewed your copyright with the stationers. And they actually kept track of grants or assignments. So they didn't go away, but they were just more involved in the process.
Did the Statute of Anne and these author protections for literary works provide any benefits for the English people, or were they really just author-centric?
So certainly the protections would give them rights for the first time to point out piracy, bring it to court, or at least get an injunction and say, hey, I am the creator of this work. I should be seeing benefits from this because I put time and money and what I would refer to as sweat equity into this. And as a result, your piracy is harming my market. And I know my market is limited. It's 14 years, and maybe I have to renew again for another 14 years. But during that time period, shouldn't I have the rights over that particular work? So we do see kind of the beginnings of what I refer to as copyright law cases. And certainly the enforcement of those laws helps protect the system. And certainly the organization by which the Statute of Anne created that protection should be enforced. So I think the benefit was I can publish my work safely now. Now, certainly piracy was still rampant, just like it's rampant today, but at least there was an end goal, which is I and my work should be respected for this time period before it drops into the public domain.
Yeah, and I guess if you're an author and you know your work will be protected, then you're willing to share your ideas and publish works that people want to read. So basically, another benefit of copyright protections would be that the public gets to promote and then have access to what's developing within England's distinct and rich national literary culture.
Absolutely, absolutely. And it wouldn't be limited to just sermons or, something that the king believes in. It could be a host of ideas in which you couldn't publish them before. So again, maybe this is the wellspring from which the Age of Enlightenment continues, because now you don't have censorship either.
Now, we said at the outset of our conversation that Americans borrowed ideas about copyright from England in particular and from Europe more broadly. Do we know what of this English precedent, this Statute of Anne, made its way over across the Atlantic to North America and influenced the development of American ideas about copyright and colonial American laws regarding copyright?
Well, what's interesting is that certainly the Statute of Anne was a major influence. The clauses and the language are nearly verbatim. The Statute of Anne's language starts with, this is an act for the encouragement of learning. When the U.S. Copyright Act was later introduced in 1790, it was titled An Act for the Encouragement of Learning. Again, all the founding fathers, many of them authors and creators, were well aware of the Statute of Anne and the history of the Stationers' Company. And as mentioned before, there was some debate and correspondence over the inclusion of limited economic monopoly. But I'd imagine that some of the focus must have clearly been on the unyielding censorship that came along with the previous English stationer system. The ideas surrounding freedom of speech and First Amendment are ingrained in the American Revolution. So they were certainly not going to endorse a pre-Statute of Anne system. Authors' rights and economic rights were tied together. But we saw multiple proposals, by the way, during the Constitutional Convention to create these types of new federal copyright laws. As I mentioned, Charles Pinckney in South Carolina, he wanted to secure to authors exclusive rights for a limited time, which works very well and sounds exactly like the Statute of Anne. James Madison made two alternative proposals to secure literary authors their copyrights for limited times and to encourage, by proper premiums and provisions, the advancement of useful knowledge and discoveries, which I think speaks more to patent law than copyright law. But both of these were referred to a committee. We don't know what happened in the committee, but we know that what came out the other side was an act for the encouragement of learning and the constitutional clause granting to authors and inventors a limited economic monopoly for their work. But again, I think the debate, and I guess you might know better than I do, would be about whether or not the monopoly was okay. And that's the problem, I think, in that normally we're talking about the history of the Stationers Company as a monopoly over these works. Would, by giving authors the monopoly in their works, upend the system? Madison had a comment in the Federalist Papers that basically said, look, despite the fact that there is a monopoly here, the utility of this copyright power, he said, will scarcely be questioned. It exists in Great Britain. It's a right of common law. It's now a statute. The public good fully coincides in both cases with the claims of individuals, both authors and creators. And so that idea is that if the public interest fully integrates with the interest of authors having exclusive rights in their work for limited times, then it works for everyone. The limited economic monopoly of 14 years doesn't surrender too much.
It's really interesting to me that you mentioned that there were many different proposals over copyright, because that seems to be distinctly American. Because you did have all of these different colonies with their own ideas about things. And then later you had all these distinct states who were just trying to negotiate ideas that they agreed upon. So I do wonder about these instances of copyright protection. What were some of the other ideas about copyright that were out there to protect authors' rights beyond that South Carolina law that you mentioned?
Sure. I mean, I'm biased. Here in Massachusetts, the first printing press aligns in 1639, well before the Constitutional Convention. And this idea of that control over that printing press and who has rights to it ended up in the Massachusetts courts. And at the time period, the Massachusetts General Court was both a combination of judiciary and legislative. That's why they still call it the Massachusetts General Court to this day, even though it's the legislature. So the first printing house was actually here in Cambridge. And what's funny is that, well, it's not funny. Unfortunately, the person that wanted to bring it over died en route. And so did his assistant. So when the printing press arrives in Massachusetts, the resident blacksmith takes it over, apparently, right outside here in Cambridge and Harvard University, which is, I think, interesting because they were looking at it like, well, this is a machine, right? So we should have the blacksmith deal with it, which is very interesting. But along comes Reverend Henry Dunster, and he's the president of Harvard. He marries the widow of the person that initially owned the printing press. And suddenly the colonies, Massachusetts Bay Colony and Harvard, kind of run this printing press as a public resource in service of this colony. And so first we see the first laws kind of arrive. And these laws are based on the distrust between the printers that were charged in printing works and the booksellers, which is absolutely fascinating. What happened is that these booksellers sold books, but function like we would think as publishers function today. So they acquire a work and then they hire a separate printer. Now, John Usher, who is around in the 1670s, and he's the son of Hezekiah Usher, one of the first and most important booksellers in the Massachusetts colonies, they had a printer named Samuel Green. And John did not trust him. He thought Green might undermine his market and sell extra copies of these publications that he's putting out. So the Massachusetts General Court grants Usher a 7-year copyright. So this is the first real grant we see in the United States. And it's basically an economic privilege, much like we saw in the constitutional narrative 100 years later. Now, it wasn't necessarily about authorship. It was more about selling extra copies and reducing risk in publishing this stuff. So we see this first kind of grant, and then Massachusetts also later grants the first state author's right to a gentleman named William Billings. He was a nationally recognized composer, singing teacher, and choir minister. The research I saw online called him the father of American choral music. And prior to the debates in Congress, around 1770, Billings was at the height of his career, and he published a tune called the New England Psalm Singer. He was very popular. And so he went to the Massachusetts court, specifically the House of Representatives, and he said, I would like to have the exclusive privilege to sell this work. And that was lost in committee, as stuff happens. 2 years later, he petitions the governor and the House of Representatives again and says, hey, look, I want to publish this book, but I want this protection. And so eventually a bill makes its way through there, and he has this right. He's empowered to print and vend his composition for 7 years. So again, this idea is that the first author in American copyright history to get his own work was this music writer. And it's rather than a printer or a bookseller. And he got exclusive privileges. So we see Massachusetts influencing this. We see the South Carolina influence. We see the Connecticut copyright influence. So a lot of these stories and the history of these colonies and what were happening certainly influenced that constitutional convention and the copyright narrative that emerged.
So to bring it back to the Constitution, as we said at the outset, Article 1, Section 8 empowers Congress to make laws to protect copyright. But before the Constitution went into effect, the people of the United States had to ratify it. And as we've just heard, Massachusetts, Connecticut, South Carolina, and other colonies and states really had different legal traditions for copyright. So Kyle, did copyright and the way that it was written into the Constitution come up within these larger ratification debates? Or did most Americans just happen to agree with this clause?
I would like to think that most Americans happen to agree with it. The convention's journals do not record any debate over the intellectual property clause, right? Most of the clause languages already appeared either in the 13 colonies themselves, the state copyright, or the drafts that were submitted. But you have to understand that many members of the convention served in state legislatures when copyright laws were adopted. So the fact that it was approved without debate doesn't surprise me too much. They probably were well aware. And as I said, Noah Webster had lobbied them and said, it's really hard to have specific state-by-state copyright. And this idea is that the Articles of Incorporation required inventors and writers to make multiple applications in each state was a pain. So the committee that passed this did it very quickly. And one of the first things George Washington did was take this power and urged action on passing the legislation that emerged from the Constitutional Convention. He said, okay, you were given this power, Congress, please act. So I think everyone was lock in step with creating this particular copyright without any kind of debate.
So when Washington urged the first federal Congress to act on copyright in 1790, how did they act? What kind of copyright protections did they wind up developing?
Sure. So he says, hey, you passed this law. And I guess he said it in January 1790. And a few months later, they had the law passed. So, Congress was quick back then. And they passed an act for the encouragement of learning by securing the copies of maps, charts, and books to authors and proprietors of such copies during the times therein mentioned, which is 14 years. So they passed this right away and kind of set up the beginnings of the copyright system. So you get an assignment of 14 years, both as creator or your executors or administrators or assignees. It's measured from when they record the print title before publication in a clerk's office, basically, at a district court, wherever you were filing. So you actually went to the court and registered. And then after that 14 years, you had a right to renew. And then you had to re-record it. Now, what's kind of cool is that the rules didn't say you needed a copyright notice on the works, but you had to publish it in a paper or newspapers within a couple weeks of your thing. So you had to register it, and then you had to say, "Dear world, I have published this. This is mine." And then you had to file a copy with the Secretary of State. Now, this is the origins of what we refer to as national deposit, that idea like I should deposit this work somewhere. Eventually, this role is taken up by the Library of Congress, which is why the Copyright Office currently sits inside the Library of Congress, because that idea of a deposit copy emerges. Now, that's a lot of requirements, by the way. So you had to register the work, you had to publish in the newspaper, you had to renew, you had to go to court, and then you had to file a copy with the Secretary of State, this deposit copy. So if you did not comply with any of these, technically, the work would be defective under the law and might drop into the public domain. So there's some great historical studies that they don't think the 1790 Copyright Act was that effective or revolutionized what authors would be doing. Between 1790 and 1800, the Library of Congress records only 15,000 works were published, but only 779 were registered. So 15,000 works, that's a decent amount if we could say that that's accurate, but only 700 or 800 of those, so that's kind of interesting that they set up this system, but it was so burdensome that it seemed to be too much.
But say you were one of these early 759 authors who filed their copyrights correctly. What kind of protection could they expect of their work? I mean, who was in charge of protecting their work, and how did the process of copyright protection work in general?
Certainly the author had the exclusive rights, right? They're the ones that can print, publish, or vend and prohibit people from making that. Now, you had to act within a year. There was a 1-year cause of action. And then you had to go to a court and you had to prove some sort of infringement and that there was some sort of monetary punishment that went along with that, right? So if you had violated someone's statutory rights of copyright, copied their book, sold it on the streets, it was 50 cents per sheet found in the infringer's possession if you're doing that. If it ended to be less than that, sometimes half of the penalty recovered went to the author and the other half went to the U.S. government. Sometimes they awarded all damages, sometimes they none. But you'd have to get in front of a court and you'd have to say, this person infringed, here's the published copies that I found, and please at least, enforce my copyright. Now, there was a ton of pirated books in this market at the time period. You have to understand that there were a lot of foreign edition works making their way into the American market. And that's because despite the fact that American authors might have been protected during this time period and under this law of 1790, foreign authors were not. So, I've seen a lot of stats saying, hey, it's great that the Americans had the copyright law, but in that time period, they were also importing tons of pirated works from other countries, most notably England, and selling them and not worrying about copyright at all.
Now, I want to bring this story more forward in time, so after we take a moment to talk about our episode's sponsor, I'd love to know more about the first major Supreme Court case concerning copyright. This episode was made possible by the Omohundro Institute, proud publishers of award-winning books since 1943, and now the publishers of acclaimed digital scholarship, too. So, what is this digital scholarship? Like the OI's books and the William & Mary Quarterly, the leading journal of early American history and culture published by the Omohundro Institute, digital scholarship is first and foremost scholarship. It's historical research that has withstood rigorous peer review, or that feedback that scholars receive from other scholars, and scholarship that has met the highest standards for editing. But unlike traditional books or William & Mary Quarterly journal articles, digital scholarship is published in a digital format, in this case, within the OI's own app, the OI Reader. And Ben Franklin's World listeners can explore this great digital scholarship for free. Just download the free OI Reader app onto your favorite smartphone or tablet device, and when you open the app, look for OpenWMQ. Within the OpenWMQ selections, you'll find a wealth of resources, including resources for the Doing History series, as well as a new digital selection called Hidden in Plain Sight by Simon Newman, our guest historian from episode 66. Now, Simon's article brings late 18th and 19th century Jamaica to life through images, interactive maps, and sound. This digital article takes you along the journeys of the men and women who escaped slavery by traveling treacherous countryside trails and then by hiding in plain sight in the busy marketplaces and towns of the day. And now you can embark on this journey for free. Just download the OI Reader from your favorite app store and explore Simon's new digital article for yourself. And once you do, you'll see why, even after more than 75 years, the Omohundro Institute is still the leading institute of early American history and culture. Okay, so we know that the federal copyright law of 1790 established copyright in the United States. But even with that law in place, Americans really continue to debate the nature of authorship and the legal protections the United States should offer to protect printed works. So Kyle, would you tell us about the first major Supreme Court case so that we can see these issues that early Americans were debating? Would you tell us about the 1834 case, Wheaton v. Peters?
Yeah, absolutely. Wheaton v. Peters is a very important case, not just for copyright, but also, I think, for access to government works and public domain and cases themselves, the copyright in the cases themselves. So as it did in England after the passage of Statute of Anne, the same question arose in U.S. courts of whether the federal copyright statute had replaced the common law copyright protection. And what I mean by common law copyright protection, I mean all the cases and laws that emerged before the statute was on the books. So they had this exact same struggle in England. We have this trouble here. In 1834, there was a case about the copyright in the publication of the Supreme Court's very own opinions, which is really super neat. So the Supreme Court was overseeing a case about its opinions. And this was between Henry Wheaton and a gentleman named Richard Peters. Now, Henry Wheaton was a Providence, Rhode Island person. He was educated at Brown. He was admitted to the bar, and he was selected by the Supreme Court in a role called the Reporter of Decisions. He was actually the third person selected. Reporters at the time were private entities, usually a single gentleman, that published the official cases of the Supreme Court and sometimes added useful additions like commentaries, annotations, summaries of the oral arguments. They were paid a stipend, I think it was $1,000 or something or less, but were expected to write all the summaries themselves, pay for all the printing materials, and they could recoup the costs of publishing these court's opinions by selling these volumes to lawyers, jurists, law libraries. And Wheaton was a noted scholar, so his reports were super accurate. They're very scholarly. But the problem was they were particularly large and they were particularly expensive, especially for that time period. So after he retires, the fourth Reporter of Decisions succeeds Wheaton, and his name is Richard Peters. He too is an attorney. He had worked on several editing jobs in the past, including scholarly titles and treatises. Peters saw his predecessor's work were too expensive. And he said, look, the average lawyer, the average American jurist probably can't afford this. So he eliminated all those extras that had been put in by Wheaton, the arguments of counsel, the annotations, the other materials. So we reduced the previous 24-volume set of the Supreme Court cases into a clean and concise 6 volumes. And they were sold for a cheaper price. And his new version was a hit. It had the right market price. Sales were up tremendously. And basically, it, took the market away from Wheaton's versions of the cases. So Wheaton sued. And he said, I have copyright in the Supreme Court cases I published. And the court actually rejected the concept that there was some federal common law that existed. They basically says, hey, we have the Copyright Act of 1790. And in order for authors to receive protection for their published works, they need to comply with this statute. And they make that ruling, which is important because it affirms that there's a federal copyright now and that the law should find that. But secondarily, and important to kind of my world, is that they also ruled that U.S. law, the cases themselves, could themselves not be copyrighted. It says no reporter has or can have any copyright in the written opinions delivered by this court. And this is because, at least in theory, that copyright is a limited monopoly recognized by law primarily for the benefit of the public. So if a public institution like the Supreme Court is putting out cases which become the law of the land, shouldn't the public automatically have access to that? That's a very interesting decision for those two reasons.
So was it this case that gave birth to the idea of fair use, the idea that the public should have a right to have access to some of these creative and scholarly written works?
Well, yeah. So certainly Wheaton v. Peters is super important in the idea of public access to law. But as far as fair use, that's a kind of a separate exception. Fair use emerges despite the fact that these authors and creators have rights for a certain time period. You can make certain small uses of these works without waiting for it to drop into the public domain. Fair use has existed in its earliest form in English law under the name of abridgment or fair abridgment. And so, like other parts of U.S. copyright law, it was formulated out of a series of English opinions where courts are trying to grapple with the true meaning of the Statute of Anne. You know, that idea of like, okay, it grants to authors the exclusive rights to the work. Are there other rights or exceptions that exist? And this is where we have, once again, the emergence of a doctrine that looks at English law and says for the American courts, maybe we should try that here as well. And if you'd like, I can talk about some of the early English cases that influenced our fair use.
Yeah, I think we're curious to hear the details of one or two of those cases.
Sure. The two that I think that stick out the most, I think are the most interesting, are basically the origins of what I said was called fair abridgment. The first one is in the 1730s, and this is when the idea of the magazine emerged, a monthly anthology of essays taken from the best weekly papers, pamphlets, book reviews, biographies, poetry, all sorts of stuff. And Edward Cave had founded something called Gentleman's Magazine, which apparently did the best of all of these things, these anthologies that existed. But of course, he was sued. In 1739, he sued by Dr. Joseph Trapp's publishers, who wrote a book of sermon and essays, and it was called The Nature, Folly, Sin, and Danger of Being Righteous Overmuch, which is, by the way, a fantastic title. And he sued Cave because Cave had printed the whole work, but by installment in Gentleman's Magazine. And Cave said, look, I never intended to print the whole thing. I printed short abstracts, parts of books, pamphlets. I do this all the time. And if anything, these little excerpts of your book might actually drive the market for the whole book. And he goes into this great argument saying, look, of a work about 70 pages, I only took about 30, which is, by the way, a lot. But he said, even then, a lot of them were wholly omitted. And I took out, pages, and I only used them about 2 or 3 at a time. And that clearly the Statute of Anne wouldn't prevent me from doing such a thing. Because isn't it the concept that we're supposed to spread knowledge and learning? Now, what I like about this is Dr. Samuel Johnson was working for Gentleman's Magazine at the time period. And for those that don't know, he is a legendary poet, playwright, literary critic, biographer. He prepared a commentary basically talking about Cave's abridgment of this book. And he said, look, hey, this is what we have. If it falls into the hands of a reader, and I quote, it's liable to be examined, censured, translated, and abridged. And these liberties cannot be prohibited without a manifest disadvantage to the public. So we see this first case where, some of the major players in the publishing market are saying, well, there should be some sort of fair abridgment of these works or fair uses. But I think the most famous one, and the one that is cited to in the American fair use narrative, is Giles V. Wilcox. This is in 1741. And this truly is not the periodical magazine version of fair abridgment. This is, I used portions of a book. So in Giles, he basically took a book, much like anyone would, and said, all right, this is the 37-page version of it. I'm going to do the 12-page version of it. And he basically took a full book called Pleas of the Crown and transcribed it into a new work called A Treatise of the Modern Crown Law. Now, the second one was written by Wilcox. And he said, look, I didn't transcribe this word for word. I added new chapters. I omitted some of the former works. I provided valuable insight and commentary. And that this concept of an abridgment is probably well within the statute. Now, the judge he was in front of at the time was a person named Lord Hardwick. Now, Lord Hardwick was born Philip York, and he was the first Earl of Hardwick. And he was sort of one of these destined to be lawyers and jurists. He'd come from a family of lawyers. He had been rapidly called to the bar at an early age and was a legal powerhouse at the time. And he had seen abridgment cases in the past. And he boiled this case down to whether the second book is the same as the former, which is smart. And he comes up with this fantastic quote. And this quote literally becomes the origins of the fair use test that we have here in the United States today. He says, where books are colorably shortened only, and they are undoubtedly within the meaning of the Statute of Anne, and a mere evasion of the statute, that cannot be called a fair abridgment. But, he says, this must not be carried so far as to restrain persons from making a real and fair abridgment. For abridgments may with great propriety be called a new book, because not only the paper and print, but the invention, learning, and judgment of the author is shown in them, and in many cases are extremely useful. So Hardwick considers these categories of real and fair abridgments to be extremely useful and well within the ideas of the Statute of Anne. So that's where we get the kind of beginnings of American law's version of fair use.
I'm really struck by the similarity between the 1741 Giles versus Wilcox case in England and the 1837 case of Sparks and Folsom versus Upham and Marsh here in the United States.
Yes.
So could you tell us about this latter case so that we can all see the similarities?
Oh, absolutely. Yeah, this is my favorite case almost ever. So again, like many of the early American legal topics, concept of fair use was, borrowed from these English cases. But in 1841, we have Jared Sparks, and he owns the copyright to something called The Writings of George Washington, which is a 12-volume work, which includes President Washington's papers, and it's published by a gentleman named Folsom. The defendant in this case is the Reverend Charles Upham, and he was a writer and anthropologist, and he took that 12-volume work, and he, once again, similarly, edited it down to a concise and slender 2 volumes. Now, he copied about 300 pages of the original, but that 2-volume work he made was called The Life of Washington in the Form of an Autobiography, and that was published by Marsh. Now, there's a lot of characters involved in Massachusetts at this time period, and Folsom alleged Marsh infringed their copyrights because Upham had copied the papers verbatim from Sparks' book. But the towering figure here is Justice Joseph Story. Now, he was the judge that heard this case. And again, he is a well-known jurist in American law, and he was, at the time, sitting by special designation in Massachusetts. At the time, they called this riding the circuit. This is the very origins of what we refer to as the circuit courts of appeal, where Supreme Court justices, rode in a carriage through a circuit and heard cases in certain parts of the country. So he heard cases here in Massachusetts, and he was holding down literally 3 jobs at the time. He was a Massachusetts circuit judge, he was a Supreme Court justice, and he was also serving as the first law professor at Harvard. So Story sees this debate, and he thinks, well, this is interesting. First, President Washington had left letters to his nephew, Justice Washington, and Justice Washington worked with Folsom on that original 12-volume work. And Story paints the struggles of a copyright case right away when he says, copyrights approach nearer than any other class of cases belonging to forensic discussions to what may be called the metaphysics of the law. And he says where the distinctions are, or at least may be very subtle and refined, and sometimes almost evanescent. And basically, this is very true of copyright law today. And he goes in and looks at Giles and looks at these other cases and looks at the Cave case and says, look, no one can say that a reviewer can't cite largely from original work, but it has to be for fair and reasonable criticism. So if you cite too much and you supersede the use of the original work and you substitute for it in some way, that's piracy. Now, there is a line between these two extremes, and that the idea is that if you have a fair and bona fide abridgment of a work, then it's not piracy. So he outlines this thing. It has to be real. It has to be substantial. It has to condense the materials in such a way that you see that there's intellectual labor and judgment in this commentary. And he says, basically, you're not just merely clever with the scissors. And that's one of my favorite quotes from this. The idea of that clever with the scissors certainly rings true today. This is a cut and paste culture, right? But it's not on computers. You know, the idea of cut and paste culture emerged from literally cutting and pasting physical works together as a form of piracy. So while the first case he looks at here, he says, look, the publishers of the second work didn't act in bad faith, but they borrowed 300 pages. It interfered with the market, and they didn't offer anything extra, that intellectual labor and judgment. But what's kind of interesting is even though this is a fair use losing case, he did not close the door on these type of fair abridgments. He found that in fair use cases, we're going to have to do a couple things. And these things that he laid out eventually become the 4 factors that become the fair use statutory code here in the United States. And he says we got to look at the nature of the objects and the selection made. We got to look at the quantity and value of the materials used and the degree in which the use may prejudice the sale or diminish the profits or supersede the objects of the original work. And that basically is the beginning of the 4-factor test, founded here in Massachusetts in 1841.
Okay, and now to bring it even closer to our own present day, how have these early American ideas and decisions about copyright and fair use influenced present-day United States laws regarding copyright and fair use?
So certainly, we all point to 1841 as the beginning of that narrative. And then in the 1880s and early 19th and 20th century, we see a lot of people citing to this work. And then eventually, we decide in 1955 that we want to overhaul the entire copyright system. And part of that overhaul becomes fair use. Now, this is a, nearly 20-year committee, right? From 1955-ish forward, we have congressional reports, we have scientists and writers and intellectuals come and debate all things copyright. And we're trying to make a copyright that is technologically neutral. We're tired of constantly having to amend the Copyright Act. When music is invented, we got a copyright in 1831. When film is invented, we got a copyright in 1909. Let's make a law that's adaptable. But inside that act, which eventually becomes the Copyright Act of 1976, we see the codification of Justice Story's 1841 decision. And that the idea that there is a line to be drawn between infringement, but also a line to be drawn for what's considered fair use. And as I said in the beginning, I think this emerges not only from the right to make copies, but the idea of censorship. Fair use says, notwithstanding the rights that the copyright holder has, notwithstanding that bundle of rights, there are certain uses that are allowed. And, they're certainly limited and they're focused, but nevertheless, they're important because imagine going back to the stationer's company, if we couldn't provide commentary or criticism on someone's work. What if we said, you always have to seek permission? So you go to a scholar and you say, I would like to criticize your work. And they could say no, and that would be the end of it. You can't have that. The system for fair use adapted from all these lessons we had learned through the English law, through becoming colonies, escaping from England, and also in setting up our own system, that we have to allow both the freedom of speech to exist and the right to use stuff before it drops into the public domain. Currently, copyright law is life of the author plus 70. Imagine, and I work in a library, so imagine you're in a library and you're like, sorry, the stacks are closed for life of the author plus 70. We can't give you access to these works until then. We would be preventing our users from accessing, using, providing criticism, commentary, scholarship on these particular works. And so I think we've learned over the 200-year or more history of the development of copyright and the fair use doctrine that these are intertwined. If you're going to get this limited economic monopoly, you also may be subject to narrow exceptions like the fair use doctrine.
Now, for those of us who may be thinking that this has been a really neat historical primer on copyright and fair use and the development of the American legal system, but why should I care about copyright and fair use? Why do you think these are ideas of the law that we really need to pay attention to?
Oh, sure. Absolutely. So this idea is that I think it's more important that we have the ability to use third-party materials freely in a way that benefits culture more than ever. I find a lot of our materials are sliding further and further away from use and ownership and into licensing. This concerns me greatly. That idea that if you sign a contract, certainly you'd be limiting yourselves. I always point to any of the iTunes or Kindle books that I am purchasing, but I'm not actually purchasing them. I'm buying them subject to a license, which basically equates them to a rental. I'm renting my music and I'm renting my ebooks. what comes along with fair use, it says, despite the fact that you may have these limitations on copyright, et cetera, that you can utilize these materials fairly, of course, to provide criticism commentary. The idea is that fair use, I believe, actually fights off, this idea of untruths, lies, fascism, if you will. And I said that last year. Fair use fights fascism because it allows us to make critical commentary on someone else's copyrighted work. And that work could be a book, a film, a movie. And that's part of the narrative of the American culture. That idea is that we should be able to access these materials and use them fairly so that we can get our ideas and our points across in things other than books. I want to be very clear that fair use is for all media types. Fair use is for everyone. Commercial, non-commercial, profit, for-profit. We all have a bite at the fair use apple if we do it correctly. And so the building of culture, whether it's mashups, sampling, criticism, commentary, documentaries, these are all intrinsically related to our foundational rights as Americans. And so I'm a full believer, if you can't tell, that fair use is one of those critical rights.
And now we should move into the time warp. This is the fun segment of the show where we ask you a hypothetical history question about what might have happened if something had occurred differently or if someone had acted differently.
The time warp. Historians can't predict the future, but they can speculate about what might have been.
In your opinion, what might have happened if the power to grant copyright protections had not been included in the United States Constitution? How would American history and American legal history be different?
That's a great question. So certainly, if we did not federalize the copyright protections in the United States Constitution in some capacity, I think we'd be left with piecemeal enforcement of copyright in state-specific areas, and that might cause illegally all sorts of, vendor shopping is what we refer to in the legal community. That idea like, well, I'm going to register in Connecticut only because at least they protect their works, but, Florida doesn't do any of this, or, Georgia doesn't do this well. And imagine trying to, as a creator or author, having to go through the burden of going to every state and registering your work just to get protection. And that might not incentivize you to continue to create that. So much like the intellectual brain drain that I was suggesting that was probably occurring in Europe with the stationer's company monopoly, wouldn't that happen here? I mean, it could be like that we wouldn't be creating these works. We wouldn't be making these movies. We wouldn't be putting forth these plays and textbooks and math books and whatever else we're making our art. Because as you pointed out, there comes some risk in exposure. And unless you support that risk with some sort of law that says, hey, for a limited period of time, we're going to pay you for your hard work on this so that you continue to create works, I would imagine that it would be impossible. I think it would change the nature of creativity and use in this country. And I think that would be very interesting. I think it would be terrible, by the way, in that we might not have the creations that we have today. Certainly, the concept of computer code and the internet and the ability to share quickly, rapidly, and the development of our technology would have been hampered tremendously by that.
So 5 years ago, in 2014, you founded something called Fair Use Week. And I wonder if you would tell us about Fair Use Week and why you created it.
Fair Use Week first emerged as an idea on the Fair Use Allies listserv. So American University went around and created something called the Code of Best Practices for Fair Use in Libraries and Archives. And it's a great document. And they had a big party in DC and they said, this document's great. And everyone said, yay. I wasn't at this event. I would love to have been, but I agreed. Basically kind of looking at how fair use is used across cultural institutions. So someone said, maybe we should do a week. And they put it on the listserv. And no one really took up the idea. In fact, they were thinking of canceling it. I had just been hired at Harvard Library in my current role as copyright advisor, and I thought I should probably justify my existence here in my job. So I responded to the listserv saying, hey, I would like to found it and do a week of activities here at Harvard. And I did. I ended up founding the @FairUseWeek Twitter handle, the Fair Use stories that we have on Tumblr. And I had experts blogging every day from around the country about this right. And my whole idea is that I think it should emerge from libraries and archives and museums, because I think we should kind of own this area of law the most, thereby allowing our users to utilize the breadth of materials that we have, but also that concept that I think this should be a right that is celebrated greatly. So the first year, I did it for a week and I made a fair use comic book and we did all sorts of fun stuff. We did a panel, we did a fair use game show. We had a lot of good times and it was very popular and got a lot of uptake. The second year, ARL, the Association of Research Libraries, contacted me and said, we'd like to partner up and make this even better. And I said, fantastic, because I'm only one person and you are an organization. And that's where we really got buy-in from other cultural institutions, other organizations that celebrate fair use. And this is when it launched, not just from a celebration that libraries have, but that worldwide people could celebrate fair use. And we actually added Canada that year to celebrate the related concept of fair dealing, which is kind of their version of fair use. And so now over 100 universities, libraries, museums, and other organizations celebrate it. It's usually the last week in February every year. We're on our 6th year.
And are there any ways for people to celebrate and participate in Fair Use Week, even if they aren't associated with a library or institution?
Absolutely. So Pia Hunter, who is at the University of Illinois, had the intuition that this was going to be a big thing. So when that call to the listserv went out, she bought fairuseweek.org. And even though they ended up not using it that year, she gave that website to ARL in the second year. So that's the focus point for a lot of our stuff. Fairuseweek.org and the Twitter handle @FairUseWeek is where we post everything that anyone's doing. We link to your blog, we link to your website, we have a calendar of events, we have live streaming stuff happening all over the United States and in Canada. And so anyone can contribute there. And of course, we have the Fair Use stories on Tumblr, in which musicians and artists and scholars talk about fair use in their work. And that's some of the best stuff that's out there, really.
Now, how can we contact you if we have more questions about the history of copyright and fair use?
Oh, sure. So I'm at kylecourtney.com, which has a link to my everything, my email, etc. And I'm also at scholar.harvard.edu/kcourtney, which also has a main contact me point. And I'm happy to hear from anyone about this because this is my subject. I'm absolutely fascinated by this. And if you want to contribute to Fair Use Week, or you want to learn more about fair use, or you want to see the new comics that we're putting out for fair use this year, let me know.
Kyle Courtney, thank you so much for introducing us to the early American origins of copyright and fair use.
Oh, it's been my absolute pleasure. Thank you so much.
Fair use and copyright is for everyone. The principles that we use here in the United States to build our national culture because they encourage the generation of new works and ideas. In fact, the bundle of rights provided by copyright was seen to be so essential that the founders of the United States made sure to specifically empower Congress with the ability to create copyright laws by writing a copyright provision right into Article 1, Section 8 of the Constitution. Now, the founders wrote this constitutional provision because they viewed copyright as something the new nation had to take control over. And this is because, as Kyle related, copyright emerged from two distinct paths. One path saw copyright emerge to protect printer and author rights to make copies, while a second path emerged from Henry VIII. During his reign between 1509 and 1547, Henry furthered his father's precedent of appointing royal printers by adding a provision. And that provision required the Privy Council to approve all books before printers could print them. So, in Henry VIII's version of copyright, he legalized his government's right to censor and control information. This is what the founders wanted to avoid. They didn't want copyright to be used as a means of censorship and control. Instead, they wanted to use copyright as a means to stimulate the development of new ideas and a new national culture. And this is why the United States borrowed from the precedent established in the English Statute of Anne. The Statute of Anne was a creators-based law. It granted authors the exclusive right to publish their work for 14 years, which the authors could renew. But after that limited period, the author's work would drop into the public domain where all could access and use it as they saw fit. Now, as we heard throughout our conversation with Kyle, early Americans used the ideas in the Statute of Anne to inform their own copyright laws. For example, like the Statute of Anne, the first federal copyright law of 1790 was a creators-based law. It secured to creators a bundle of rights that for a limited period of 14 years allowed them to decide how they would disseminate and profit from their original work. And then, once that limited period was over, their original work became the property of the American people. Of course, in order to secure these rights, a creator did have to do some legwork. They had to file their work with the local court clerk, advertise their filing in newspapers, file a copy of their new work with the Office of the Secretary of State, and go through the entire process again when and if they filed for a 14-year renewal of their rights. Now, over time, American courts further defined this law. For example, in 1841, Justice Joseph Story outlined that copyright really needed to maintain a balance between a creator's copyright and the public's ability to use their copyrighted works fairly. Creative and scholarly works inspire the creation of new ideas. Therefore, Story saw that there needed to be a limit to copyright protection because, like many Americans, he didn't want copyright protections to prevent the very thing that they were supposed to promote, the creation of new works and ideas. So, in Folsom v. Marsh, Story allowed that Americans could abridge original works if they did so fairly, and also added something new that turned the original work into something new. And this is where we see the origins of the American fair use doctrine. Story recognized that if copyright law did not allow for fair use, then American culture and learning would stagnate. If everyone who wished to build upon previous ideas needed the permission of the original idea creator, well, Americans would generate very little new knowledge and learning. Now, American copyright law has continued to change over time. In 1976, the United States created a new law to bring all of its copyright and fair use laws up to date with the 20th century. The new law is called the Copyright Act of 1976, and it was meant to grant copyright and fair use protections in a media-neutral way. And like its early American antecedents, it too borrowed from the laws and ideas about copyright that came before it. Now, one last idea I'd like for us to consider is Kyle's request that we think about copyright and fair use in the 21st century. Specifically, Kyle asked us to consider how technology companies are shifting our right to use and protect our creations from copyright agreements to licensing agreements. And this is something that has some serious implications for us to think about if we still believe creative and scholarly works can help us create new ideas and build our national culture. Licensing agreements have proliferated in our digital age. In a licensing agreement, a creator grants permission for a publisher or service to distribute their creation in a way that extends specified portions of their copyright protections. Essentially, licensing agreements take advantage of a loophole in the Copyright Act of 1976. In that act, Congress specified that the fair use doctrine, that doctrine that allows us all to fairly use copyrighted materials to educate and create new ideas, well, Congress specified that the fair use doctrine applies only to unlicensed materials. So what does this mean? It means that if you as a creator license your creation to a digital delivery service, like those provided by Netflix, Amazon, or iTunes, those companies can grant or not grant permissions for users to access and use your creation. And if they don't grant permission, it could mean that libraries may not be able to provide people with access to the information or creative work you created. It could also mean that teachers may not be able to use your work as that great example of something that they're trying to teach their students. Additionally, all access to your creation may become dependent upon a subscription. So if a school, library, or subscriber stops paying for their subscription, people may lose access to your creation. These are ideas we're thinking about. And as we've heard throughout our conversation today, copyright and fair use laws have always been something that Americans have adjusted over time so that they best serve their needs. Today, we live in a different century. Ours is a content-rich digital world. And right now, the Copyright Act that's governing that world was written in a pre-digital age. You can find more information about Kyle, Fair Use Week, plus notes and links for everything we talked about today on the show notes page, benfranklinsworld.com/227. The Omohundro Institute's Digital Projects team has created bonus materials for this episode so that you can further investigate the early American history of copyright and fair use. These materials include graphic comics about the history and origins of fair use, a list of books about these subjects that you may wish to check out, and a special blog post by early American copyright expert Nora Slanimsky called The Public Figure Exceptions: Finding Fair Use in the Vastness of Early American IP. Plus, we have bonus audio. It's a listener Q&A featuring Kyle answering your questions about copyright and fair use. This bonus audio and all of these other materials are only available in the OI Reader app. So open the OI Reader app on your favorite smartphone or tablet device, or head on over to your favorite app store and download the OI Reader app for free. Now, in addition to writing a special blog post for this episode, Nora Slanimsky also shared her expertise in early American copyright and intellectual property with me. Nora is the Gardner Assistant Professor of History at Iona College and the director of the Institute for Thomas Paine Studies. She's working on her first book, The Engine of Free Expression, Copywriting the State in Early America, which won the Zuckerman Dissertation Prize in 2018 from the Society for Historians of the Early American Republic. Thank you for all your help, Nora. Production assistance for this podcast came from the Omohundro Institute's Digital Projects team. Joseph Edelman, Kim Foley, Martha Howard, Emily Sneff, Holly White, and Karen Wolf. Finally, is there a book, film, podcast, blog, piece of music, or work of art that really helped you come up with a new idea? I'd love to know about the works that have really inspired you to create, so please share them with me. Liz@BenFranklin'sWorld.com. Ben Franklin's World is a production of the Omohundro Institute.
And remember, never leave till tomorrow that which you can do today.